Hi, everybody. I am Holly Celiano, and I have my guest today, Mr. Brent Johnson. Before I get into that, I'm going to play my disclaimer, and then we will go into who Brent is. All opinions expressed by the program participants are so current opinions and do not reflect the opinions of the host or their respective affiliate partners with which the program participants are affiliate may have been previously disseminated by them. The program participants' opinions are based upon information they deem reliable, but neither the host nor its affiliates warrants its complete accuracy, and it should not be relied upon as such. This is for informational and educational purposes only. Thank you. So, Brent, let me just pull up a little bit about who you are for the audience that doesn't know anything about you. Brent is the director of Freedom Bound International, a common law service center educating people about their sovereign rights. For more than 30 years, Brent has experienced more success than anyone else in teaching practical methods of living free from the endless encroaches of Big Brother. Brent is truly a modern day freedom fighter. So, welcome, Brent, to the show.
Thank you, Holly. I'm glad to be here with you, and I'm looking forward to our conversation.
Yes, and I thought it would be great because we've had a little bit of controversy with Mr. X, and then a bar attorney wanted to come on. And you are the opposite end of that spectrum, working on being a common law practitioner and helping people to escape from the entanglement of the regular legal system. So I wanted to first ask you, for people who don't know, what is common law?
Okay. Common law is the unwritten law of social interaction. It predates all government, so therefore no government can abrogate or cancel or eliminate common law. And as a matter of fact, in the United States, all statutory law has a clause in it that says all of this body of law must be in harmony with common law. It has to be there because statutory law cannot overwrite common law. Also, if you look at the original, the organic Constitution, not the corporate fiction that exists today, but if you look at the organic Constitution, every time it uses the word law, it is referring to the common law, because back then this was not a discussion. This was obvious. The best way to sum up common law is this: that you can do anything you want as long as you do not violate, as long as you do not directly violate the life, liberty, and property of another. It is pretty much summed up in the Ten Commandments, but that's the simplistic gist of common law. And while attorneys may learn a little bit about common law in their training, it's not a lot. It's very, very little. And so I've actually taught attorneys because they don't really know a lot about common law. And today, what is called statutory law doesn't actually exist. There is nothing that, if you look in the various foundational documents of America, you won't find anything that talks about statutory law. It is a fabrication that has come out of administrative law, which essentially is maritime law.
Thank you. So are we operating under the maximus of law or statutes and codes and case law?
Who's we in that question?
Well, attorneys representing you.
Okay. Attorneys, and by the way, the gentleman you had on the air, he did discuss a little bit about what attorney means, but he did not discuss the linguistic foundation, which is from the French. And what it means is twister of words.
Mhm.
That's what attorney actually means.
Which people say that's legalese. Attorneys
Yes.
talk legalese, which is twisting of words.
Yes, exactly true. But What was the original question? I
So
apologize.
do attorneys use the
Oh,
maxima of law or the statutes and
okay.
codes and
Now,
case law?
at- attorneys absolutely always deal with statutory administrative law. That's what they're trained to do. Many years ago, I appeared as a guest at a trade show in the outskirts of Dallas, Texas. And a gentleman from Montana traveled to see me. He wanted to see me speak and hear me speak. So during the event, at one point or another, he and I sat down, and he was extremely knowledgeable and studied in common law. He decided he wanted to take a course in how to pass the bar. So he did. He signed up for a course in how to pass the bar. Now, when they give you a course, essentially, you have a tutor for the course. And the tutor was teaching him this and that about how to pass the test and all of that. And this guy kept asking questions that came from his framework of education and common law. And after a while, the tutor said, look, you're going to have to stop asking me these questions, because in this course, I'm going to teach you a new way to think about the law. And that's when he quit the course. But the moral of the story, the lesson of the story is, by the time you get your bar card, you have learned a new way to think about the law. And that's true for all attorneys. And by the way, I have a friend who has been an attorney for all the time I've known him, and I've known him for 25 years. And so he was an attorney well before then. He used to work for the Virginia Attorney General's office, which in public life is about as high as you can get without having an elected position. And after he attended my seminar, and he sat in the front and he was taking copious notes, and this was a 10-hour seminar, and he got through and he checked everything out, and then he quit his job with the AG office and he went into private practice to use his knowledge of law and administrative law to help people, which to this day is what he is doing. So just because somebody, I mean, the gentleman you had on the air said this, just because somebody is a bar card carrying attorney doesn't necessarily mean, okay, that he's a terrible person.
Right.
It does mean that he's involved in a system that is counterproductive to what ordinary people want for themselves.
Right. Exactly. So attorneys believe that they're taking an oath to the Constitution. And the Constitution, as you and I know, and everybody that's very awake and aware, there's two different constitutions that we're operating under. There's the U.S. Constitution, and then there is the Republic Constitution. So when an attorney is taking an oath and they think it's to the Constitution, what are your thoughts on that? What one are they swearing an oath to?
Well, truth be told, I think that when people in today's culture take an oath, frankly, I think most of the time they don't have the foggiest notion of what they're taking an oath to. I mean, I would include everybody in Congress. They take an oath. They put their hand on the Bible, said, "Do you promise to do this, that, and the other thing?" Sure, I promise. I don't really believe that most of them, there may be exceptions, there probably are, but I really don't believe that most of them have any idea that to which they are swearing an oath to. Many of them don't have legitimate oaths. We know that for a fact. Every single public official, whether elected or appointed, is required to have on file an oath that binds that person to respecting the Constitution. Doesn't specify which Constitution, or, you know, just because you call it the Constitution doesn't really identify. Every state has a constitution. Actually, they have two. The country has a constitution. Every country that professes to be either democratic or a republic of the type that we actually have in America, every single one of those countries has a constitution. So the Constitution is kind of a relatively meaningless phrase. And and like I say, many of the people who are required to have an oath don't have an oath. And that means judges. Judges cannot sit and adjudicate a matter if they don't have an oath of office. Attorneys cannot do it unless they have an oath. Administrators can't do what they do unless they have an oath. And this has just been disregarded because the government today is staffed by criminals, people who do not follow the law. That's what makes them criminals. And so when you're dealing with criminals, they don't necessarily care about honoring lawful oaths.
Right. So we were talking offline before we got on, and there is a Latin word that attorneys follow. Would you talk about that?
You're talking about Corpus Juris Secundum.
Yes.
Okay. Corpus Juris Secundum, or CJS for short, is a body of law that is foundational to all processes of law. There are many volumes of it, many sections in it. But the section I'm going to mention to you here, and you can look it up for yourself, is Volume 7, Section 4 of Corpus Juris Secundum. And this identifies the duties of an attorney, the primary duties of an attorney. And the first duty of an attorney is, as an officer of the court, his or her first duty is to the court itself. The second duty of an attorney is to the bar association. That's his personal bar association, and the central headquarter bar in America is the Illinois bar, and that goes to the #1 top of the chart bar, which is the London bar. And so all bar associations in America report, would be a good word to it, to the Illinois bar, and from the Illinois bar to the London bar. BAR stands for British Accredited Registry. That's what it stands for. It is an acronym, British Accredited Registry. And under Corpus Juris Secundum, Section 4, Volume 7, it says the second duty of the attorney is to the bar. The third duty of the attorney is to the client. Now, that means that if there is any conflict between the duties that an attorney has, between what the court wants, what the bar wants, and what the client wants, the client loses. Now, that every attorney is bound by that. An attorney cannot sit there and say, well, I don't like that, so I'm going to act differently. That would be a violation of the terms of being an attorney. So that's #1. And I kind of, when I watched your presentation, your interview with the bar attorney, I was sitting there saying, boy, I wish I could talk to him, because that would be what I would bring up. But the perhaps more significant element is also found in notations under Volume 7, Section 4 of CJS, is a reference to the client. The client is considered to be a ward of the state. Anybody who hires an attorney is considered to be a ward of the state. And I'm sorry, ward of the court, not ward of the state, ward of the court. Now, in this same body of law, Volume 7, Section 4, just before it, Section 2 addresses this. And it says that clients are wards of the court, and a ward of the court means infants and persons of unsound mind placed by the court under the care of a guardian. So basically, the old saying of the person who defends himself has an idiot for a client or something like that is a bunch of crap. If you hire an attorney, you are considered a ward of the court.
Wow.
And That's it. Unsound of mind. I mean, you're incapable. I mean, that's basically, and everybody rushes to hire an attorney because the attorney knows more than they know. The other thing about common law is the word common. Okay, common law is very easy to understand. There isn't legalese, there isn't legal trickery. If you're in a common law court, there are no attorneys there. Attorneys are not allowed there unless the attorney is a party to the action. Then the attorney is allowed there. The judge is a referee and nothing more.
Right.
In a common law court, you actually have trial by jury, which you don't have in any administrative court. You would say, oh, yeah, they have jury trials. Yes, they do have jury trials. It is not the same as trial by jury. Trial by jury means the jury is actually asking questions of the witnesses.
Wow.
The trial is being conducted by the jury. The selection of the jury is random. It's put a bunch of names in a hat and pull them out. And unless somebody is a relative or has a direct involvement with one of the accused parties, that person is able to sit on the jury. You don't have an attorney sitting there saying, do you like Donald Trump? Well, I'm disqualifying you, because attorneys have carte blanche to disqualify. They have a certain number of disqualifications from a jury pool that they are automatically allowed. I don't like the way you look. I don't like the color of your skin. I don't like that you're a man. I don't like that you're a woman. Any reason at all. It's Tuesday. I'm disqualifying you.
Right.
And they can do that, but they cannot do that in a common law trial, a common law assembly, where the jury is selected randomly, the judge is a referee, and there are no attorneys and no legal trickery. The plaintiff, if you will, gets to say what the charges are, what I'm accusing this guy of doing, and then the defense gets to say, I didn't do it, and explain it, and they get to submit whatever evidence they have, and then the jury decides.
And that sounds like a much fairer way, because the way we are now, there's always so much misconstrued and so many innocent people go to jail
Oh,
or
yeah.
get fined that shouldn't be.
Well, we've lost sight of the famous invocation that, and it actually originates with William Blackstone. Okay, but it's often quoted as Thomas Jefferson's. I would sooner see the original one. I would sooner see 10 guilty people go free than one innocent incarcerated. Jefferson, revisited it as I'd sooner see 100 go free than one incarcerated. But it's the same principle. You are innocent until proven guilty. Today, all you need is an internet accusation and
Right.
the world said, that's it, he's guilty. Look, I saw it on Google.
Right.
And
So-
and by the way, the police are actually taught that everybody is guilty of something. Therefore, whoever you're dealing with, that's a guilty person. That's how they're trained.
We need a lot of revamping. So another question for you. Mr. X had said that your rights are left out in the hall when you walk into a bar court. Is that correct?
Yes. Essentially, it is. If you are knowledgeable, you can stop that. First off, okay, any waiver of rights, it's like entering an agreement into a foreign jurisdiction. Anytime you enter into an agreement, there are 4 component elements required for that agreement to be valid. Your entry into the agreement must be a knowing, intelligent act, entered into intentionally and voluntarily. 4 component elements. So knowing means you know what you're doing. You are of sound mind. Intelligent act means you have thought about it. You're not acting impulsively. Intentional means you intend the consequences of your entry into the agreement. And voluntary is voluntary.
Mhm.
And so if any of those 4 is not true, then your entry into the agreement is fraudulent. You can't be tricked into it, something like that. The truth is that all courts today, at least all official courts today, are under maritime jurisdiction, admiralty jurisdiction. Now, they call it statutory jurisdiction, but again, you will find nothing in any body of law that says statutory jurisdiction. It doesn't exist. It's a made-up term. And when you enter that courtroom, you do not have the fundamental common law rights that a judicial proceeding provides you. Number one, you have the right to face your accused. How many times have you heard about court cases that are done via Zoom?
Mm-hmm.
Well, how do you know that who you're looking at is really the person that, how do you know you're facing your accused?
Right.
You don't. Okay. But they do this because it's easier. It's easier.
So a question.
You have the right to defend yourself. And that means that you have the right to say what you wish to say in defense of the charges. Look at Donald Trump. The judge said, "You can't talk. I refuse to let you talk." And this kind of stuff goes on all the time. So yes, you are denied your fundamental rights, and they consider that you have voluntarily done that. Now, until you say, "I have not voluntarily given up my rights to a proper judicial proceeding under common law," if you don't say that, they presume that you have.
So is that if you're knowledgeable in common law like you are, and you have something that gets you into the court systems, how do you navigate within that judicial court system? Because they tangle you up in legalese. You really need to know your standing and your rights. Most people don't have the full knowledge. How do you try to win a court case?
Well, before I answer that question, I want you to understand this is not something you can have a step-by-step handbook on.
Mm-hmm.
Everybody wants that. Everyone wants that. Show me the right document, and then I'll be okay. Okay, whatever the document is, it never protects you. It's just a document. And this is really important because people get themselves in a lot of trouble because somebody makes a good argument, says this sounds great and everything, I'll do it too, and they find that they encounter all kinds of problems and don't know how to deal with it. So that's the first part of my response. But it's interesting you asked that. I'm currently involved in a case. I have a client, okay, who has chosen not to pay the federal income tax. And many years ago, the client set up a common law trust through me and put his house in the trust. Many, many years afterwards, the IRS challenged him and decided that he owed them money and went through a whole process and everything. And one day, I get a notice that the trust that has nothing to do with the client has been named as a nominee of the client. And the IRS is suing the client and naming the trust. Now, the trust itself is not under the jurisdiction of the statutory court. And I so stated. The judge then came out and literally threatened me. He said, "One more word from you and I'm going to find you in contempt. This is a federal court hearing and you have no right to speak on behalf of this trust. Okay, doesn't matter that you're the official representative of the trust. You have no right to speak because of the rules of this court say you have to have an attorney." So I literally was forced into that situation. Currently, they're going through a process of depositions, and they are trying to undermine me by forcing me to participate in depositions, not just as a representative of the trust, but they want to subpoena me in my personal capacity. I've told the lawyer in no uncertain terms I won't do it. I've drawn a line in the sand. Okay, I've made it clear. I have never waived my common law rights. I have never waived my right to stand on behalf of the entity that has been falsely charged in this situation. They have produced no evidence to support their claim. I mean, I went down a laundry list with him. As a matter of fact, after I'm off with you, I have to contact him and respond to a couple of questions he sent to me. But I've told him, if this is not conducted properly, I will not participate. I simply won't.
Wow.
Sometimes that's exactly what happens, because you literally are forced into a situation. Now, I have it on record. The judge, he literally threatened me. I mean, I was providing answers. I was providing him challenges to jurisdiction. He disallowed everything because you have no standing in this court. Well, good. I'll leave then. What do you want me in this court? And the IRS simply decided, because they want the house. That's what they want. Okay. They can't get the house from the guy they're going after because he doesn't own it. So they made up a story, and they just said, that's it. We're going after the trust, which, by the way, when they filed their notice of lien and named the trust, I had correspondence with them. They ignored my correspondence, just said, we're going to ignore that. We're just going to go forward. So all of that is in the record, and even though I'm skilled, I'm still in that situation. It's kind of like anybody can sue anybody for anything. That's the truth. And
even for freedom of speech, as I just found out.
Because the rules of those courts do not follow common law. If they did, none of this would happen.
Right.
And the important thing is to not accept it, not give it. In other words, I'm still sitting there saying, yeah, I've got representation, but it's because it was forced on me. And that's my argument. And if they end up ruling against the trust, which, by the way, in 30 plus years has never happened, but if they end up ruling against the trust, I have strong grounds to appeal to the circuit court, which generally will look at the law itself rather than the administrative procedures. Even so, I hate being in court because you just can't trust it, regardless of what the law says.
I agree. I have a couple of more questions to get through. Is the gold fringe flag telling you you're in a captured arena?
The gold fringe flag is actually called the general's flag. You will find it in Title 4 of the U.S. codes. And it indicates maritime admiralty jurisdiction. Admiralty jurisdiction is jurisdiction outside of the boundaries of the United States of America. Okay, on the high seas, for example, that's admiralty jurisdiction. So anytime you have a gold fringe flag, the flag indicates that the proceedings are under its jurisdiction. That's what the general's flag means. I have actually, I gave a speech at I think it was a Lions Club many years ago. I don't remember, Colorado, Nevada, somewhere out there. And I walked in, and there was a gold fringe flag, and I said, take that out of here. I will not speak in here. I will not conduct this speech here until you remove it. And they removed it.
Wow. Is all caps name through the USPS to your home to a dead fiction entity?
Okay. All right. Now, here you're going to get into what I call commercial law remedy theory, which, by the way, doesn't work. It doesn't work because showing the law to criminals does not do any good. Go up to a guy who's robbing a bank and say, excuse me, did you know that robbing a bank is illegal and you can go to jail for a lot of years? He's not going to thank you and go home. He'll probably shoot you and he'll still rob the bank. So showing the law to a criminal doesn't get the criminal to do anything. That's why showing a cop who pulled you over the Constitution does no good. And commercial law remedy theorists believe that if you just do it right, it will get you there. It will get you what you're attempting to do in 30 plus years. I know some of the original architects of this process. Nobody's ever gotten anything out of it. Now, having said that, one of the arguments under commercial law remedy is the argument about the straw man. And the straw man is a real thing. That absolutely is. The argument is that in your birth certificate, your all capital letters is used to get loans out based upon your future earnings as a taxpayer. That's the argument. And you are therefore entitled to at least some of those earnings. Now, where the argument falls flat is the idea that the straw man, that the capital letter is a reflection of you. It is not. It is the creation of the state used to get you to agree to subject yourself to the state. But it is the creation of the state. And even commercial law remedy people will admit that, because they'll go into court and say, this is not me. This thing against, capital B, capital R, capital E, capital N, capital T, etc. Johnson, that's not me. And if they state their case correctly, frequently the case will be thrown out. So they are clear that's not me. Well, if that's not you, you have no claim on it. How
Right.
can you say I have a claim? Well, because it looks like my name. Excuse me? No. So I do not accept that the straw man is something that you have a claim against. Now, you don't like your birth certificate that way? Fine. Cancel your birth certificate. You can do that. You don't have to agree to it. Yeah. You don't have to accept going into court if the court charges you in the all caps name, because that's not your name. So you have options there. But to sit there and say, well, you're entitled to trillions of dollars because they used your name, while on the immediate opposite end, you're saying, well, that's not my name. You can't have it both ways.
Right. I have one final question. So there are attorneys that have an ISLN, International Standard Lawyer Number, which is a foreign agent number. Are you familiar with that?
I am not.
Okay. Well, there are attorneys that have that, and just wondering, why would an attorney have a foreign agent number?
I do not know the answer to that, but I would have no doubt that it is used in some way to cement the jurisdiction under which they operate. But I'm really not familiar with it, so I can't comment intelligently about it. That's just a guess.
And you know what? I apologize. I do have one more question written down.
Sure.
Would an attorney operate out of a trust?
Okay, first off, a trust can be statutory and a trust can be non-statutory. So my answer is, yeah, of course, attorneys will operate out of trust. Now, a statutory trust, an attorney will operate out of, sure. A common law trust, highly unlikely.
Okay.
Now, at the same time, I know people who are attorneys who have put their own property into common law trusts. Okay, so that can be done. But when you say operate out of, it generally means either representing or in some way acting on behalf of the trust.
Well, what I mean is, would they be conducting law business out of a trust?
Statutory trust, sure.
Okay.
Common law trust, almost certainly not. I won't say not, because there could always be the exception to the rule.
Okay.
But as a general rule, if you have a common law trust does not have an EIN. There are people who have common law trusts that have EINs, and when you get an EIN, the trust becomes a statutory trust. So if you have a common law trust and you have not compromised it by getting an EIN, an attorney will generally not do anything with it. It will not recognize it, because in the attorney's world, everything has a taxpayer ID number.
Got it. So do you have any final closing comments you want to say to the audience?
Yeah, I will say this, that I know that Mr. X at one point went on the air and said it should kill all the lawyers. That is an unwise thing to say. Number one, in today's climate, okay, where saying the wrong word becomes an actionable offense. Number two, even if you feel that way, saying it, especially in a broadcast venue, can actually incite people to do really bad things. And you don't want that. You don't want that on your conscience. You don't want that on your shoulders. You know, if you are blessed with the ability to use the airwaves to communicate a message, please communicate that message in a way, okay, that inspires and supports people rather than takes them down. Having said that, okay, I can appreciate why he would have said such a thing, and he may feel it seriously, or he may have taken it as kind of a sideways joke. The other thing is that I know attorneys who are very good people and very honorable people. So it is very unwise to splash a designation across an entire race or an entire professional association, because almost certainly it does, whatever your designation is, it doesn't apply to everybody. Right. in that association. So I would just ask people to be a little bit more conscious about the consequences of what they say. Okay, not tone down what you do, not tone down your commitment. Personally, and I've said this before, I think all the criminals in government should be hanged in public. Okay, I don't have a problem saying that, because there may be some non-criminals in government, and I'm not talking about them, but right. I am talking about the criminals in government, the people who have undermined the rights of people, who have destroyed people's lives, who have killed people. How many times have you heard of a cop who pulls somebody over and the person in the car ends up being shot? Well, I thought he had a gun. And that justifies the taking of a life that was created by God. Mm-hmm. Okay, that person, in my mind, should be hanged. I think hanging is a good idea, because people get to see the dead body in the square, and it's a deterrent to others. Having said that, I say it in a credible way. Most people, they might disagree with the punishment, but they wouldn't disagree with the sentiment of, punish the people. The other thing I want to do is just give out contact information. If you'd like to get in touch with me, I have a toll-free number. Won't cost you anything. It's 888-385-FREE. That's 888-385-3733. And my website is www.freedomradio.us. freedomradio.us. I would invite you all to get a copy of my book, The American Sovereign: How to Live Free from Government Regulation. It is the #1 book on sovereignty in the world. It is a tremendous book. You start it, you won't be able to put it down. If you loan it out, you will never get it back. And finally, I want to thank you, Holly, for all that you are doing to bring truth, honor, and justice as a message to your audience.
Thank you.
Thank you so much.
It was a pleasure having you on. This was a great, I feel well-rounded with this whole discussion on all of this legal stuff. So you brought a whole nother perspective on, and it was great. So we'll have you back on again and talk about this in further depth. So thank you for coming on, Brent.
Thank you, Holly.
Have a great day.